Hey everybody, it's Joel Williams and Chase Elleby from Williams Elleby coming to you today with week number 29 of our video series of 52 weeks of personal injury. Last week we talked to you about how to file a lawsuit, and this week we want to talk to you about what happens after you file a lawsuit. So Chase, once a lawsuit's filed, what's the first thing that you can generally expect to happen?
So once you get it filed and you get it served, typically what's supposed to happen, and most of the time it does, the other side files what is called an answer. Right, they're basically answering the complaint, and they'll go through every paragraph that's in the complaint. They'll have their answer to each paragraph, and they serve it upon the the plaintiff. And usually with that answer comes what we call discovery, things like interrogatories, which are written questions, and requests for production of documents, which are the other side asking for documents from us. Things like, in a personal injury case, it's going to be medical records, medical bills, photos, things like that. So that's usually the first step.
Yep, and sometimes if you didn't get what we discussed in week 28 correctly about how to properly file the lawsuit, and if you file it in the wrong place, you may get a motion to dismiss that the other side will file. So that's why it's so important to make sure you file your lawsuit correctly, because the other side, if you don't do it correctly, may file motions to try to get the court to throw your case out right out of the gate.
Exactly. Yeah. So typically, you'll see those motions on the front end. You can also see other motions throughout the whole litigation process, but the motion to dismiss most always comes pretty frequently or pretty quickly in the beginning of the lawsuit. Once you get past that, you go into what's called the discovery phase. I talked a moment ago about actually sending interrogatories and written questions. That's part of the discovery phase. The other part are things like taking depositions, doing inspections, hiring experts to get them to start reviewing documents and things like that. So you get into that process, which typically in Georgia, for just your kind of run-of-the-mill civil case, is a 6-month process. Most of the time that gets extended because it's very hard to get a lot of things done in a 6-month period when you're dealing with multiple parties, multiple lawyers, and a lot of stuff that kind of has to get done in a short period of time.
Yeah, if it's a very simple case, sometimes you can get it done in the 6 months, but if there's multiple law firms, there's multiple witnesses, and you're trying to coordinate all those schedules, it can extend beyond that 6 months. Yeah. But also, after you file the lawsuit, and keep in mind, this is just a very general overview. We'll go into more detail about each aspect of this in subsequent videos. But usually after, or sometimes during the discovery phase, the parties will engage in mediation. And mediation is just a formal settlement conference where you get an older lawyer or a retired judge or really just any lawyer with adequate experience that's tired of being in the fray, kind of battling it out every day like we do, to come in and serve as a neutral. And they'll hear both sides' arguments about the strengths and weaknesses of the case. And they basically try to broker a deal. And they're not on anybody's side. Their goal is to get the case settled. In Georgia, we're fortunate. We've got a lot of really good mediators, but we also have a lot of stubborn insurance companies. So the success of a mediation really depends on how reasonable the parties are when they come to try to get the case settled.
Right. And sometimes mediation is required, court ordered, right? Let's say you have to go to mediation. Sometimes the parties just agree, hey, this might be a good case to try to mediate. So mediation is always a great thing to do if the case calls for it. So if you can't get the case resolved in mediation, you've already gone through all the discovery process and all that, the next step would be trial, right? So trial, depending on the case, can last anywhere from a day or two to weeks, months, just really depends. And then that really takes a lot of time, a lot of effort, a lot of preparation, but at the end can be very rewarding for the client, depending, of course, on the case. So
yeah, and lots of times, well, not a lot of times, sometimes we get calls from people who have handled everything on their own up until this point of trial, and then they go, oh crap, I got to try this case, I need to get a lawyer. If you've done everything else on your own, don't call me and ask me to come try your case, because I'm not going to do it. In order to have a successful trial, you have to file the lawsuit correctly. You have to engage in proper discovery and do a good job with it. You have to have everything organized properly. You got to have all your ducks in a row. You got to be familiar with the evidence rules and how you've preserved things to get ready for trial. So trials are not easy, and most lawyers are no good at it because it's hard. And you don't do it a whole lot because a lot of cases resolve either pre-suit or in settlement or during mediation. But anyway, the next step, if the case can't get resolved after discovery, is trial. And I would encourage you to not find yourself in a position where you're having to try the case on your own, unless you're in a court like magistrate court in Georgia and you have a very small claim where evidence rules are kind of loosey-goosey. But make sure you just get a lawyer way before then, so you're not trying to figure out how to try a case all on your own under pressure.
Yeah, speaking of not trying to do things on your own, same with the appeals process, right? So if a trial goes sideways, either if you win, you lose, the next step could be potential for an appeal. You can ask a bunch of lawyers, a bunch of judges who've seen pro se where people try to file their own appeals. Talk about rules. There's so many rules to follow when you file an appeal that there's just landmines all over the place. But typically, going back to on topic, that's the next step after trial. If you get a great verdict or you lose, you always have the option to appeal. You can appeal to the Court of Appeals, and then depending on what the Court of Appeals does, you can appeal to the Supreme Court of Georgia. And if it's a federal case, you can go all through the federal appellate courts as well. So that's kind of the last line or last step in the process.
Yep. So all in all, after you file a lawsuit, generally the defendant's going to file an answer. They're going to hire lawyers. They're going to file an answer admitting and denying things in the lawsuit. You're going to enter into a discovery phase where you exchange information and documents and take testimony from the other side. You'll probably go through a mediation where you try to have a formal settlement conference type thing. If it doesn't settle, you're going to have a trial and then possibly an appeal.
Yep.
And that can last anywhere from 1.5 years to as long as it takes to go up and down the appeals process, which can be quite significant. So that's just a general overview of what you can expect after you file a lawsuit. And like I said, in subsequent videos, we'll go into more detail on each aspect of that case. But if this video has been helpful to you, give us a thumbs up. Put some comments in the section below if you can think of anything else that you should expect after filing a lawsuit. And subscribe to our channel. We appreciate our subscribers and are thankful for everybody that follows along with our efforts to produce these videos. So otherwise, we will see you next week for video number 30.